We begin our stories today with the abortion pill restriction that was recently ordered into place by a Texas district judge. The Texas judge ruled that the RU-486 medication, which has been authorized for use by the FDA for about 20 years, didn't go through the proper approval process and ordered that the drug be discontinued. The Fifth Circuit Court of Appeals has taken a look at this on an emergency interlocutory review and overturned the decision from the district court in part. So let's read that. The Fifth Circuit Court of Appeals has issued an order that will temporarily allow a widely used abortion pill, RU-486, to remain on the market, but imposes restrictions that will alter its ability to be used. The 42-page order issued by the Fifth Circuit Court of Appeals late Wednesday, in effect, returns restrictions on the drug to what they were before 2016, when the pill could only be used to about 7 weeks of pregnancy, required in-doctor visits, and couldn't be sent to patients through the mail. That would be the critical part of the decision there, is that it can't be sent through the mail, at least for the moment. So the drug can be used, but it has to be used as per the 2016 guidelines, which required the in-doctor visits and prohibited mail use. So that's what the Fifth Circuit seems to think. The three-judge panel seems skeptical of the plaintiff's challenge to the drug's approval. Yeah, I'm also skeptical. I read the underlying decision from the district court. It seemed a little shaky to my mind, but the Fifth Circuit was persuaded by arguments that the U.S. FDA had failed to properly scrutinize more recent changes that loosened access to the drugs. Okay, so that kind of makes sense, at least partially, right? So trying to go all the way back to 2000, when this drug was initially approved, and trying to undo all that at this point raises obvious problems. But 2016 is more in line because the period to challenge a federal regulation, I believe, is 5 years, is to challenge a federal regulation. And there is some basis to say that the initial regulation was properly challenged and properly timed, and it just took this long to do it. But that is obviously a bit of a harder case than the 2016 revisions themselves need a look at, right? That the idea that the 2016 revisions reopened the original 2000 decision is a bit of a harder sell. It's not impossible legally, but it is difficult. And the district judge, at least to my mind, didn't do themselves any particular favors in trying to make that decision. So the Court of Appeals says, okay, instead of going all the way back to 2000 when this drug was initially approved and trying to undo all that, what about the 2016 decision when the FDA reopened the issue and made it issue? Maybe we can challenge those decisions, and those decisions are more timely challenged. That's obviously an easier sell to say that that's within the period, right? They only have to be challenged within a 5-year period, and they were challenged within that period. And so saying, okay, those decisions are not properly vetted, so we go back to the way it was in 2016, at least is more legally tenable. Now, whether or not that's the right decision is a whole nother set of problems, but it does get around some of the timeliness issues that the district judge was facing when they were trying to go all the way back to 2000. It's less hard to sell. So the Court of Appeals saying, let's go back to 2016 makes a little bit more sense on the timeliness issues of the challenge. The plaintiffs had argued that even though their challenge to the drug 2000 approval appeared to be time barred, the FDA had essentially reset the clock by making subsequent changes. That's a hard sell, right? The FDA makes changes all the time. It's that it reopens the original decision every time they make changes. That seems a little bit more difficult. The appellate panel wasn't persuaded. Although a close call, we're unsure at this preliminary junction. After truncated review, the FDA opened the 2000 approval. Yeah, I don't know how close a call it is, to be honest. But then again, the Fifth Circuit is looking at this in an emergency posture. So while I'm not sure I would necessarily personally describe it as a close call, I appreciate the Fifth Circuit's more cautious language because they're looking at this in an emergency posture on a truncated review, because of course this isn't the result of a district decision that has fully been done. This is an injunction that comes relatively early in a case. So there has not been as much stuff by the district court, and the Fifth Circuit is acting in a very expedited manner. So they are taking a more cautious approach, and I understand that. However, the court said it appeared that the FDA had failed to examine relevant data when it loosened restrictions on the drug in 2016, which would allow the pill to be used up to about 10 weeks of pregnancy. The judges said the agency relied on studies that included some restrictions that it was eliminating. The judge's ruling is, of course, not the final ruling, and they are scheduling oral arguments on the next available date. So the Fifth Circuit still is taking a look at this. They put in place an emergency order, and the Fifth Circuit is still taking a fuller look at this to act in a more deliberated fashion as time would allow for. The Justice Department has asked the appeal court to rule on the request for stay so the administration would have time to seek review. The White House press secretary said that they're going to continue to fight it on the courts. We believe the law is on their side and will prevail. The pill, known as mifepristone, also known as RU-486, and also by some other names for that matter, is used in more than half the abortions in the United States. I actually think it's quite a bit more than that, but whatever. The U.S. District Judge ruled Friday that the FDA had improperly approved the drug in 2000 under a pathway used for medications to treat life-threatening illnesses and failed to adequately assess safety. So the district judge had some ideas that the drug was improperly approved in 2000 in improperly improved mechanisms, but there are some issues there on the timeliness of the challenge. There are some issues there on some underlying issues. There's also, of course, Chevron in terms of the administrative agency interpreting what an emergency is and not. So there are kind of a bunch of issues that district courts seem to improperly ignore. Dozens of parties have filed amicus briefs, including more than 300 members of Congress, 55 Justice Department officials, and Democratic and Republican state attorneys general. A collection of pharmaceutical companies have filed briefs saying that the ruling would allow to harm drug development. Yeah, the pharmaceutical companies have pointed out, and not completely improperly, that this decision raises some real problems when it comes to district judges' ability to do things with respect to the FDA. That a single district judge could potentially ban any drug that's been approved by the FDA for whatever reasons they want to. And that is obviously a bit of a problem because the FDA is the one that determines what drugs are safe and effective, and there's a process for that. And a single judge could potentially overturn that with respect to any drug, and that raises some real concerns. And the pharmaceuticals company their concerns is not completely invalid. Thus, that brings us to the end of discussion of the current state of the issue with respect to this abortion drug, misoprostone, also known as RU-486, where this drug has been in the news because of this district judge decision from Texas, and the Fifth Circuit, for the moment at least, has put in place a sort of compromise decision where they say, okay, we'll just go back to what it was in 2016. So that would prevent it from being used in the mail and require in-person visits, but would otherwise make the drug available in states in which it is available. So that will, for the moment, bring us to the end of discussion of that story.